In this video, we're going to consider some of the complex issues for copyright law that are raised by databases. So databases form an important part of the economy and they're important to businesses. But the question has come up, how does the law protect them? They do seem to be a form of intellectual property that does seem worthy of copyright protection. But as we'll see, there are some difficulties with this. So like a literary work, a database is valuable and we want to incentivize the production of databases. They can be expensive to develop. And like literary works, they're like really easy to copy. So they do have the feel, the whiff of something that should be protected by copyright. But when we take a closer look at the rules governing copyright protection, we'll see that it's quite tricky. Most databases contain facts. And how is a collection of facts protected by copyright? Facts themselves can't be protected, so how can a collection of them be? So copyright law is quite clear that it does not protect facts. So Paris is the capital of France, that's a fact. There can be no copyright in that fact. But what happens then when we have a collection of facts? Can a collection of facts be protected by copyright? Now, this issue first came up in 1865 in Kelly v. Morris. So the Post Office London directory was updated and published every year. And so this was a list of businesses in London with their addresses. The Imperial Directory of London was published by a competitor, and it used information about businesses for its 1865 edition. And it was clear that it had done this because some of the errors in the Post Office London directory were reproduced in the Imperial Directory of London. So it was clear that the Imperial Directory of London hadn't compiled its own information. Now, the court found that this was a copyright infringement, even though the directories only contained facts. The judge stated that the defendant has been most completely mistaken in what he assumes to be his right to deal with the labour and property of others. So you can see here we're talking about the labour test. In the case of a dictionary, map, guidebook or directory, when there are certain common objects of information which must, if described correctly, be described in the same words, a subsequent compiler is bound to set about doing for himself that which the first compiler has done. So even though these facts could only be expressed in the same way ultimately, the labour that someone has expended in compiling them can't be appropriated. In the case of a road book, he must count the milestones for himself. He is not entitled to take one word from the information previously published without independently working out the matter for himself, so as to arrive at the same result from the same common sources of information. And the only use that he can legitimately make of a previous publication is to verify his own calculations and results when obtained. So in the present case, the defendant could not take a single line of the plaintiff's directory for the purpose of saving himself labour and trouble in getting his information. And this is very much applying the labour test of originality. And even though the judge concedes that if Morris sent out people door to door to gather this information about London himself, that information would be expressed in exactly the same way, he has to do the legwork himself, in this case literally. The labour used in compiling Kelly's directory cannot be appropriated. It's wrong to reap the fruits of other people's labour. So it's very much the labour test at work here. Now we can see that in terms of originality, in terms of creativity, there's not a lot going on in a directory. But it's the labour that's important, the labour in compiling it. is protected. The work of the defendant has clearly not been compiled by the legitimate application of independent personal labour. The Merger Doctrine states that where there are a very limited number of ways to express an idea, then the idea and expression are said to be merged. And since you can't copyright an idea, the expression can't be the subject of copyright either. So there may be scenarios where there just is very little choice in how you can express the idea. This came up in a very interesting case in 1890, Kenrick v. Lawrence. Kenrick was a printer, and around this time the voting franchise was being expanded in Britain and more people were being allowed to vote. Some of these people did not have very good literacy, and so Kenrick had the idea of producing cards with a drawing that explained to people how to vote. So it was a hand holding a pencil, putting an X in a box. And these cards were very popular and they were quite a success. And so Lawrence, a competitor of his, decided to print his own version of the cards. And these were almost identical. Kenrick sued, but the judge found that, well, there's really only one way to express that idea. The idea of a hand holding a pencil, marking a box, can really only be expressed in one way. And since it was impossible then to separate that expression from the idea, because they had merged, then the expression could not be protected by copyright. So this raises questions then for compilations of facts. How many different ways can you express a particular fact, like the price of a postage stamp? And so this issue has come up with timetables and TV listings and football fixtures and horse racing fixtures and stuff like that. Now, a very similar case came before the courts in 1944. It's nice to see that copyright law continued to progress despite what else was going on in London at the time. The law marched on nonetheless. So Cramp produced diaries, and these contained tables of facts. And we still see that in paper diaries today. At the front you've got a calendar, you have conversions from, meters to imperial units. That's a common thing, for example. And Cramp's diary had dates of holidays, postage rates, things like that, conversion tables. And an interesting one was light-up times. It seems that the appropriate time to turn on the lights on your car was something that people were inclined to look up. And of course, nightfall fell at slightly different times in different towns. And so there was actually a table you could look up to see whether you should turn on the lights of your car or not. It's hard to fathom today why someone needed to look that up. But the important point here is that all of these things were facts. There was no originality gone into devising them. The date of a holiday is the date of a holiday. The number of feet in a metre is just a fact. The phases of the moon are just a fact. So Smithson published diaries in competition with Cramp, and Smithson just went away and copied Cramp's tables. Cramp sued, and Smithson's defence was that there can be no copyright in mere facts. And the court initially found for Cramp, but the case eventually went to the House of Lords, which found that there was no copyright infringement, because there was no copyright in facts. The Lord Chancellor stated that a summarised statement of the most important of the postal charges, inland, imperial and foreign, is part of the ordinary contents of any pocket diary. There would be considerable difficulty in successfully contending that ordinary tables, which can be got from or checked by the postal guide or the nautical almanac, are a subject of copyright as being original literary work. One of the essential qualities of such tables is that they should be accurate, so that there is no question of variation in what is stated. The sun does in fact rise and the moon does set at times which have been calculated, and the utmost that a table can do on such a subject is to state the result accurately. There is so far no room for taste or judgment. There remains, I agree, an element of choice as to what information should be given, and the respondents contend that the test of originality is satisfied by the choice of the tables inserted. I have difficulty in seeing how such tables, in the combination in which they appear in the respondent's 1933 diary, can reasonably claim to be original work. There is no evidence that any of these tables was composed specially for the respondent's diary. There was no feature of them which could be pointed out as novel or specially meritorious or ingenious from the point of view of the judgment or skill of the compiler. It was not suggested that there was any element of originality or skill in the order in which the tables were arranged. My own conclusion is that the selection did not constitute an original literary work. Now, one of the things that distinguishes this from Kelly v. Morris is that it seems in this situation the original publisher didn't have to invest a whole lot of labour in producing the tables himself in the first place. The postal rates would have come from the post office, and some other information would have come from a nautical almanac. Whereas in Kelly v. Morris, the compiler of the directory essentially sent people from door to door. And we see here too a reference to the Merger Doctrine. The moon sets at a particular time, and there isn't really a whole lot of choice in the number of ways one could express that. Now, one of the things that distinguishes this from Kelly v. Morris is that there doesn't appear to have been a great deal of investment in labour by the original publisher in compiling the information. So the postal charges could be gotten from the postal guide and other information from a nautical almanac. And he notes here that there is no evidence that any of these tables was composed specially for the respondent's diary. Whereas in Kelly v. Morris, for example, Kelly essentially went from door to door. He did a lot of legwork to gather that information. We see also elements of the Merger Doctrine here. The moon sets at a particular time, and that's the time it sets, and there really is a very limited number of ways one could express that. And as we've seen with the Merger Doctrine, if there isn't scope for different kinds of expression separate from the idea, well then the idea and expression are merged and the result is not protected by copyright. So the main issue is here that the content is not original, and it's not original because there wasn't a whole lot of labour employed to gather it in the first place. And then secondly, there's some merger going on. Lord Macmillan stated that, to my mind, the collection is of an obvious and commonplace character, and I fail to detect any meritorious distinctiveness in it. Everyone expects to find in his pocket diary some useful general information about rates of postage, weights and measures, and significant dates and the like. Probably no two series of diaries contain precisely the same collections of tables, for they will vary according to the compiler's ideas as to what is likely to be useful to the purchasers whom he seeks to attract. But there must be a number of items, such as rates of postage, common to them all. The inclusion or exclusion of one or more of the tables constituting the ordinary stock material of the diary compiler seems to me to involve the very minimum labour and judgment. As I have said, and as the authorities remind us, the question must always be one of degree, and on questions of degree different minds may naturally reach different conclusions. For myself, I should say that if any compilation could be held to fall short of displaying the qualities requisite to attract copyright, the respondent's collection of 7 tables is such a one. Lord Macmillan stated that, I do not doubt that, as the annals of literature show, a high degree of knowledge and skill may be displayed and much labour and judgment expended in gathering from the wide fields of non-copyright material at the disposal of the public specialised collections of extracts designed to meet particular needs or particular tastes, but it must always be a question of degree. Not every compilation can claim to be original literary work, even in the pedestrian sense attributed to these words by the law. Thus, to take a familiar example, it has been held by this House that to compile from the official timetables of the railway companies a local timetable showing a selection of trains to and from a particular town is not to compose a work entitled to copyright. Such a compilation may be convenient and useful for the inhabitants of that town, but it does not require either such labour or such ingenuity in its preparation as to render it fit subject matter for copyright. And so again here, the labour is the issue. How much labour does it really take to extract that information? Now, the House of Lords was also acknowledging that a compilation can be a literary work, but not every compilation. And although there was acknowledgement that the threshold was actually quite low, in this case it was still below that threshold. Lord Porter stated that it is conceded that if the work, labour and skill required to make the selection and to compile the tables which form its items is negligible, then no copyright can subsist in it. Whether enough work, labour and skill is involved, and what its value is, must always be a question of degree. Different minds will differ, as may be seen in the present case from the divergence of the opinion in the courts below. Speaking for myself, it appears to me that it is of the smallest. So the labour, work, skill, judgment, that's still the test here. And there is acknowledgement that the compilation of tables could require some or all of those things, but in this case, there simply wasn't enough of it. So more recently, the same question has come up again. Similar questions about the originality of directories came before the courts in the US, and Feist Publications versus Rural Telephone Service went all the way to the US Supreme Court. And the Supreme Court held that White Pages telephone directory could not be protected by copyright. So the names and numbers were listed in alphabetical order. And the order in which they were listed was an important factor in this case. And one of the justices stated that it may seem unfair that much of the fruit of the compiler's labour may be used by others without compensation. As Justice Brennan has correctly observed, however, this is not some unforeseen byproduct of a statutory scheme. It is rather the essence of copyright. The primary objective of copyright is not to reward the labour of authors, but to promote the progress of science and useful arts. To this end, copyright assures authors the right to their original expression, but encourages others to build freely upon the ideas and information conveyed by a work. So here we have the justice going back to the justifications for copyright. And the primary justification is not to reward the fruits of labour, but to provide benefits to society. And the justice said later on, this principle, known as the idea expression or fact expression dichotomy, applies to all works of authorship. As applied to a factual compilation, assuming the absence of original written expression, only the compiler's selection and arrangement may be protected. The raw facts may be copied at will. This result is neither unfair nor unfortunate. It is the means by which copyright advances the progress of science and art. So here the court is saying that individual facts cannot be copyrighted because of the idea expression dichotomy, where there's only one way to express the fact. And so if a collection of facts is to be protected by copyright, there must be an assessment of whether the selection and arrangement of them is worthy of protection. Now, this does seem to suggest that the selection and arrangement may be worthy of copyright protection, but the facts themselves never. And here the Justice set this out quite plainly. Many compilations consist of nothing but raw data, i.e. wholly factual information not accompanied by any original written expression. On what basis may one claim a copyright in such a work? Common sense tells us that 100 uncopyrightable facts do not magically change their status when gathered together in one place. Yet copyright law seems to contemplate that compilations that consist exclusively of facts are potentially within its scope. Now, what appeared to be essentially the same question came before a lower court sometime after, and this was in Bell South v. Donnelly Information Publishing. But in this case, the court found that the yellow pages, or the golden pages as they might be called in Ireland for other intellectual property reasons, that the yellow pages could be copyright material because skill and judgment was expended in devising the classification system. And so here, like the white pages, the facts themselves are not protected by copyright, but in the yellow pages they were organized by a classification system. And that's what distinguishes the yellow pages from the white pages, where the names are just listed alphabetically. There's nothing original in the organization of a bunch of names in alphabetical order. But in the yellow pages classification scheme, there's skill and judgment expended in doing that. So European law has tried to deal with all of these tricky issues surrounding protection for databases. And there's a 1996 directive known as the Database Directive, and this sought to provide copyright protection for databases. And it required member states to introduce a two-tier copyright system for databases. So there's an original database, that's one category of copyright, and then there's the sui generis database right. And in both of these cases, protection is independent of the copyright status of the individual works contained within the database. It kind of goes without saying that if some of the contents of the database are independently original and worthy of copyright protection, then the database as a whole is worthy of copyright protection. But in this scenario, we're only considering what happens when the contents of the database itself are not worthy of copyright protection. In what circumstances does the collection of those uncopyrightable items become protected by copyright? And of course, this is a question of some importance. I mean, most companies' customer databases, for example, do not contain entries that are by themselves worthy of protection. The vast bulk of databases by their very nature contain essentially facts. So what then is an original database? So databases can be considered original databases if by reason of the selection or arrangement of their contents, they constitute the author's own intellectual creation. So you can see here, we're not talking about labour and skill and judgment, just the author's own intellectual creation. Now, as computer scientists, we know that setting up a database, organising the tables, normalising the tables, deciding what goes where, that's not a trivial task. That is valuable work that should be protected. And the finished product of that work is not necessarily represented by code. And of course, the code to access a database is separate from the database itself. But insofar as the design of a database, which is the selection or arrangement of their contents, that constitutes the author's own intellectual creation, the database will be deemed to be an original database. And as we've seen, the threshold is, typically quite low. And the second part of Article 3 there just points out that this is entirely separate from the copyright in the contents of the database. The contents of the database might or might not be protected by copyright depending on their own circumstances, separate from the database. So the test then for an original database is by reason of the selection or arrangement of their contents, it is the author's own intellectual creation. Now, it turns out that before the Copyright Directive, the UK protected databases as literary works anyway. And of course, this can often happen with a directive. It may be that the thing that the directive is requiring the member state to do has already been done. And in Ireland, original databases are listed in Section 17 as something that's protected. So, along with sound recordings, films, typographical arrangements, original databases are also protected. This is slightly different from the UK, where the definition of literary work was expanded to include original databases. Now, the database right is a whole other right that is separate, and it applies to databases even if they are not original. So if a database is the author's own intellectual creation, yip-de-doo, that's protected. But if it's not, it may still be protected using the database right. So this right applies to a broader range of databases. So where there has been significant investment in the obtaining, verification, or presentation of data, the collection of data is protected. Now, yet again, this is irrespective of the value of any individual pieces of data. And there's no requirement here for any particularly ingenious or special arrangement that represents the author's own intellectual creation. So even if you failed both of those tests, your database might still be protected by the database right. And in Article 7 of the Database Directive, it states that member states shall provide for a right for the maker of a database which shows that there has been qualitatively and or quantitatively a substantial investment in either the obtaining, verification, or presentation of the contents to prevent extraction or reutilization of the whole or a substantial part evaluated qualitatively and or quantitatively of the contents of that database. So the test here is the investment. And so you can see here we have European law drawing on the English law tradition. And that's because a database is not necessarily going to be an author's own intellectual creation. And so that bar might be very high. But where a substantial investment has been made, the sui generis database right can protect the investor, the developer of the database. And so this can incentivize the generation and production of useful databases. So in Ireland, this is in section 321, a property right to be known, and in this part referred to as the database right, subsists in a database where there has been a substantial investment in obtaining, verifying, or presenting the contents of the database. Now, the database right then prevents others from using the database without permission. And very importantly, even where permission is granted, that cannot be abused to recreate the database. So if I have a database, for example, and I allow access to it from the internet for free, people can come and use the database and they can access it as much as they want, but they can't abuse that access to extract huge chunks from my database piece by piece and reconstruct it and build their own database out of it. So Article 7 of the Directive states that the repeated and systematic extraction and or reutilization of insubstantial parts of the contents of the database, implying acts which conflict with a normal exploitation of that database or which unreasonably prejudice the legitimate interests of the maker shall not be permitted. So even if you take tiny bits at a time, but you unreasonably prejudice the legitimate interests of the maker, that's not allowed. Now, the database right then has come up in unusual circumstances. People who have produced listings of sporting fixtures have attempted to assert their sui generis database right in those listings. And they've attempted then to prevent others from using those listings. And a very good example is bookmakers who want to list events that the public can bet on. And the question has come up, in listing those events, are they infringing the database rights of the people who compiled the fixtures? There have been a few cases involving databases at the European level. The Court of Justice of the EU has been called on to clarify the meaning of some areas of the directive, and the most significant case was the British Horseracing Board versus William Hill. But like so many other database cases, it involves sporting fixtures. The British Horseracing Board compiled and maintained a database that contained a lot of information about horse owners, trainers, and others involved in the racing industry. A part of that database contained information about races that were held in the UK. This part of the database contained the names of horses and the place and date of each race and the distance and the prize money. The database was available to the public via the British Horseracing Board website. Now, William Hill is a well-known bookie in the UK, and the company launched an online betting site that allowed customers to bet on the outcomes of races. That's what bookies do. William Hill took information about the races from various sources, including newspapers and other publications. The British Horseracing Board claimed that it had a sui generis database right in that information, and that William Hill was infringing that database right by publishing the race fixtures. It's not entirely clear if William Hill was getting the information just from newspapers or whether there was some screen scraping going on from the BHB website. But the crux of the matter is the same either way. The judgment in this case is quite long and quite detailed, and if you're interested in this area, it really is worth reading in its entirety. So, the British Horseracing Board lost. The court found that it was clear that the British Horseracing Board had invested considerable resources in the development and the maintenance of the database. But for a database to be protected by the database right, that investment must be in obtaining, verification, or presentation of the contents of the database. The Court of Justice of the EU drew the distinction between this type of investment and the initial investment in the data itself. It found that the material used by William Hill was quantitatively insubstantial. So William Hill didn't take very much of the whole database. It also found that the portion that William Hill took, namely the race listings, was not the subject of the independent investment required from its creation. And it also found that William Hill's repeated and systematic extraction and reutilization of insubstantial parts did not reconstitute or make available to the public the whole database or even a substantial part of it. So BHB's case failed on two main points. First, the investment in obtaining, verifying and presenting the information wasn't evident for the data in question. And secondly, what William Hill took was insubstantial. We learned quite a lot from the BHB case. Investment in the creation of the data does not qualify for database right protection. and that was the principal investment that BHP had made. The investment had to be in verification or obtaining existing data. That's what's required for the database right. We also got some clarification from this case on what substantial means. And what substantial can be assessed quantitatively or qualitatively. Quantitatively is simply the volume of data used compared to the volume of data in the database. But the qualitative assessment is more subtle, and this considers how much of the investment in obtaining and in verifying and presenting the data is being used by the person extracting without authority. And the important point here is that the intrinsic value of the data itself is not relevant when making that assessment. We also learned from this case that repeated and systematic reuse only counts as infringement of the database right if it amounts to reconstituting a substantial part of the database. So that provision is designed to stop someone from reconstituting the protected database by extracting one piece of data at a time. But if that's not going on, then there's no infringement. Another interesting thing we learned from the judgment is that the database right can be infringed indirectly. Now, in this case, it was found that there was no database rights infringed, but had the disputed activities been infringing, the fact that William Hill didn't interact with the BHP database directly and only got the information from a third party, like a newspaper, wouldn't have been enough to get it off the hook. Infringing indirectly would still have been an infringement. So we can see from this case that the sui generis database right grants database owners quite significant and sweeping protections, but the bar for getting that protection is quite high. And most importantly, the intrinsic value of the data itself is not a factor that's considered. If the database is protected under the database right, then that right lasts for 15 years. We can see that in section 325 of the Act in Ireland. If there are substantial changes to the database, then the clock is reset. Curiously, the database right only protects databases created by EU nationals or residents. The main reason for this is that not many other countries recognise this right. And if they're not going to protect European databases, then European law isn't going to reciprocate and protect their databases. The Berne Convention doesn't have an equivalent of the European sui generis database right, so it's on a pre-Berne or nationals only type of basis. So it's worth recapping now on the different kinds of protections for databases in Europe. If the contents of the database are original and they are protected by copyright, then it kind of goes without saying that a collection of those individual elements is also protected by copyright. But if the content of your database is original, then you shouldn't even really be thinking about database protection. It's bog standard copyright. We are most interested in using database protection when the contents themselves are not worthy individually of copyright protection. So this collection of non-copyrightable works may itself be protected by copyright, provided that by reason of the selection or arrangement of their contents, they constitute the author's own intellectual creation. Now, you'll notice there's no mention of labour or skill or judgment here. So if the organising structure is the author's own intellectual creation, then the database is protected by regular copyright. Which brings us then to the next scenario. So even if the arrangement of the contents is so mundane that it doesn't meet the author's own intellectual creation criteria, the database may still be protected by the sui generis database right. That applies where there has been investment in either obtaining, verification, or presentation of the contents. And in this scenario, you can stop people from reaping the benefits of the fruits of your investment by reconstituting the database. So this sort of goes back to Kelly v. Morris, where the work was protected by virtue of the investment alone, notwithstanding the complete lack of any degree of originality. Now, of course, a high-quality database may meet the criteria for all three kinds of protection, but it is important to understand the distinctions between them. Now, the database right comes up a lot in cases involving screen scraping. As most of you know, a system or a piece of software might grant access to the services it provides by means of an API. This allows other software to plug in and interact with it, often in order to extract some information. And there might be a fee associated with this, with some kind of credentials required in order to gain access to the service. However, where no API is made available for whatever reason, it may be possible to extract information from a database using the publicly available front end on the web. So if Ryanair, for example, doesn't want to give me access to its flight details, I could go to the website essentially posing as a potential customer and take all the information I need. We call that screen scraping. And indeed, Ryanair is currently involved in a few cases about screen scraping, but they're complicated by the issues of incorporating terms into contracts. And as we know, the formation of contracts online is a bit complex. But if we consider just the database issue, is it acceptable for a software developer to go to a website like Ryanair or like Irish Rail and scrape the information that it wants? Well, this came up in the case of Dublin Bikes. So in Dublin, bikes are provided for short-term rental across the city centre. And the company operating the scheme listed the number of available bikes at each of the rental locations. An app developer wanted to integrate this information with location-based services to provide potential customers with details of nearby available bikes. However, the company operating the scheme claimed a database right in that data, and so the app was pulled. Another example is Aircode. It's not that long ago that we introduced postcodes into Ireland. And although any individual can look up a postcode using the website, companies that need to access lots of them have to pay. If someone wanted to construct their own Aircode database, the database right would probably prevent them from doing so. You could imagine a consortium of companies like Amazon and other online retailers that do business in Ireland that could probably very quickly compile a database covering most of Ireland's online shoppers, just from the information provided by these customers. But such a database might be considered infringing of Aircode's database right, even if these companies never went near the Aircode website, because that infringement can be indirect. So to recap then, an original database is covered by copyright irrespective of the copyrightability of the contents. As long as there is some input in terms of the selection or arrangement of the contents, that would constitute the author's own intellectual creation. An entirely unoriginal database is protected by the sui generis database right. That's not copyright per se, although it feels quite similar. The systematic extraction from such a database in order to reconstitute a substantial part of it is prohibited. So these two types of protection show us how the law can stretch a bit to encompass new scenarios thrown up by new technologies. But also how sometimes it just can't stretch far enough, and so entirely new rights and new forms of protection have to be created. And that's what we have in the original database protection and in the sui generis database right.